Welcome to How Recent Changes in Probate Laws Impact Your Cases. Thanks for being here this afternoon. I am Jennifer McNeil-Lozano, co-chair of the BHBA's Trust and Estates Law section. Before we begin, I'd like to take a moment to thank our sponsors. The Trust and Estates section is sponsored by Bond Services of California, Liberty Mutual Surety, California Title Company, Pickford Escrow Company, and the Sanborn team. Today, I'm delighted to introduce our speaker, the Honorable Susan Greenberg. Susan L. Greenberg brings over 4 decades of Bay Area legal experience to signature resolution, including 26 years on the San Mateo County Superior Court bench, where she held supervising assignments across family law, civil, and probate courts, and guided the court through the COVID-19 pandemic as criminal presiding judge. Before the bench, she served as a deputy district attorney and ran a private civil practice spanning personal injury, family law, real estate, and probate matters. Judge Greenberg is known for her tenacious pursuit of resolution, her candor about litigation risk, and her ability to uncover the true drivers of a dispute, qualities that are consistently produce settlements where others have fallen short. Thank you for being here, Judge Greenberg, and now let's get started.
Thank you for having me, and thank you, Jennifer, for that warm welcome. So good afternoon, everyone. Next slide, please. This is me. I very recently actually retired from the San Mateo County bench, and when I retired, I was the probate judge and the probate supervising judge. Let's get right into it because there's a lot to discuss. I just want to say now that if we run out of time, I will invite you to write down, you can see it, it's written there, my cell phone or my email address, and either email or text me if you need any of the citations that I discuss or have any questions that we can't get to during the presentation. And I'm serious about that. If you do want to ask questions and we run out of time, please feel free to contact me. All right, so let's begin. California trust law has really changed quite a bit in the last 5 or 6 years. This is really geared to attorneys who have a practice where they advise settlers, trustees, beneficiaries of trusts, and additional areas of probate, including we'll discuss a little bit about tax laws and other similar issues. We're going to start with a case called Haggerty v. Thornton. That is a decision that was extremely important in the trust arena. It became law in 2024. To understand Haggerty, let's go into the statutory framework, which is Probate Code sections 15400, 15401, and 15402. So 15400 is really about the presumption that a trust is revocable. It establishes that unless a trust instrument expressly makes the trust irrevocable, it is revocable by the settlor. Moving on to 15401, that actually describes the methods of revocation. And it basically provides 2 different manners in which a trust can be revoked. This is for a revocable trust, of course. First, the settlor can comply with any method of revocation specified in the trust instrument. Second, the settlor may use the statutory method, which is a writing other than a will that has been signed by the settlor and delivered to the trustee during the settlor's lifetime. Those are the basics. 15402 deals with modification by and revocation of a trust. So in 15402, that provides that unless the trust instrument provides otherwise, if a trust is revocable by the settlor may modify the trust by the same revocation procedure as in modification. All right, so we've got 2 different issues. We're revoking the trust or we're modifying the trust. And here's where the issue got a little bit difficult for the appellate courts over many, many years. Haggerty basically resolved these differing appellate court decisions. When Haggerty was decided by the California Supreme Court, it resolved this split among the appellate courts. So basically, what the appellate courts were divided on was one fundamental question, and that is when a trust instrument specifies a particular method of modification, such as an acknowledged instrument in writing, does that alone make that the trust instrument's method of exclusive method of modification? And that was where the appellate courts were divided. Some said yes, others said no, you could still use the standard revocation procedure found in the codes. So here's what happened in Haggerty. Here are the facts, and it's really very instructive. In Haggerty, the settler, Jean Birch, creates a revocable trust in 2015, and she reserves the right to revoke or amend the trust by an acknowledged instrument. Acknowledged means notarized, an acknowledged instrument in writing. In 2016, she executes a notarized amendment, adding her niece, Brianna Haggerty. And Brianna Haggerty becomes a beneficiary by that 2016 amendment. Then in 2018, Ms. Birch removes Haggerty and adds other beneficiaries. In 2018, when she does this, she executes the Second Amendment, she signs it, but she doesn't get it notarized. So it's not acknowledged, an acknowledged trust instrument or an acknowledged amendment instrument as was stated in her initial trust. This question was really the heart of the question of all the other appellate cases with slightly different facts, of course. What did the Supreme Court hold? Next slide, please. The Supreme Court held the following, that under 15402, the trust may be modified as just like in 15401, the same procedures for revocation, which include that statutory method, unless the trust instrument provides a method of modification that explicitly makes it exclusive or otherwise explicitly precludes the use of the revocation procedures for modification that you find in the code. So this absolutely decided the issue. Unless your statement, unless Ms. Birch had said the only way, this is the explicit way that you can modify this trust, and it has, you can't use what's in the code, this is the only way, is an acknowledged instrument. And she didn't say that. Unless she had said that, then the 2018 amendment wouldn't be valid. But she didn't say that. So the court found, yes, you can use what she put in her trust, but you can also use the ability to modify that you find in the code. So that's basically what happened in Haggerty. This disapproved the prior decision. So there were a number of prior decisions that were disapproved by Haggerty. King versus Lynch, 204, Cal App 4th, 1186. Balistreri, 75, Cal App 5th, 511. Diaz versus Zuniga, 91 Cal App 5th, and those that I've listed in the table of authorities. There's so many. They range from 2019, actually one goes back to 2012 and 1995 even, all the way through 2023. So this really was a sweeping decision that resolved this issue. And the Supreme Court looked at legislative history in making its decision. They looked at the Law Revision Commission's commentary on 15402 and determined that the commission's goal was to expand the availability of the statutory method of revocation also to go equally to modification. So very, very important. Next slide, please. So post Haggerty, there's been some case law that's very important. And it deals with attorneys in cases that are trying to now use Haggerty in various ways. So we'll first look at Trotter versus Trotter. So that Trotter Van Dyke. That's a pretty interesting case from 2024. It's 103 Cal App 5th, 126. And the Court of Appeal there did apply Haggerty, but found that the purported trust amendment was still invalid. Here we have a case of attorneys who are trying to say, look, here's an unsigned writing, and under Haggerty, we want it to be confirmed as an amendment to a trust. And the court said, yeah, that's not happening. That's me paraphrasing, of course, what the court said. But seriously, that's taking it a little bit too far, obviously. And that's what happened in Trotter versus Trotter Van Dyke. It illustrates that Haggerty expanded the available methods of modification, but did not eliminate the baseline requirement of having a signed writing, which we all know is required under 15401. Then we can look at Packard versus Packard. So in the Packard case, what happened was there was a petition for construction and reformation of a trust amendment. And the question was, does that constitute a trust contest subject to the 120-day limitation periods under Probate Code Section 16061.8? So interestingly, the court reasoned that whether a petition constitutes a trust contest must be determined by reference to the purposes the trustor sought to attain through the trust, and that a petition seeking to give effect to the trustor's intent through reformation is not a challenge to the trust's validity. So this distinction is really significant in that clients who miss that 120-day window may actually still have a viable reformation claim. Finally, we'll look at Govner versus Superior Court. That is a case from 2025. And in that case, the Court of Appeal held as a matter of first impression that the probate code will govern the timing for filing a demur to a petition brought under the probate code. And that was very interesting because attorneys in that case were arguing, oh no, it should be the civil practice rules. The court found that that was not the case. Next slide, please. All right, so there have been legislative developments that have occurred that we need to discuss. There are new trustee duties and beneficiary rights that we need to talk about. So first of all, there are expanded beneficiary rights when a settler becomes incompetent. And we see this all the time in probate court, that a settler becomes incompetent. And now we've got the issues between the trustees, the beneficiaries. There's all kinds of problems that arise when a settler becomes incompetent. So prior to the 2021 and 2022 amendments, Section 15800 of the Probate Code provided that during a period that a trust is revocable and the settler is competent, the trustee's duties run to the settler and not the beneficiaries. The 2021 amendment actually was effective on January 1st of 2023 because there was a 2022 amendment, and that significantly expanded beneficiary rights when the settler loses competency. So basically then what's going to happen under the amended statute is that when no person holding power to revoke the trust is competent, the trustee must within 60 days of receiving information establishing the settler's incompetency, they must provide notice and a complete copy of the trust and all amendments to the trust to each beneficiary who would be entitled to receive income or principal if the settler had died as of that date. This is important. It really gives the beneficiaries the opportunity to come forward and make a motion or do what they feel is appropriate in the probate court when they learn that the settler has become incompetent. In addition, the trustee's annual accounting duties shift to those beneficiaries, and incompetency may be established either by a method specified in the trust instrument or by judicial determination. So if there's a fight about whether or not the settler is incompetent, that can be brought before the probate court. So this really creates new significant compliance obligations for trustees and new rights for beneficiaries when you've got an older person as a settler of a trust. All right, going on to the 120-day trust contest limitation period. We know that section 16061.8 provides that a person who is served with a trustee's notification under 16061.7, which is required when a revocable trust becomes irrevocable on a settler's death, that person may not bring an action to contest the trust more than 120 days from service of the notification or 60 days from a date a copy of the trust terms are delivered during that 120-day period, whichever is later. We've got Hamilton versus Green, 98 Cal App 5th, 417 from 2023, where the Court of Appeal held that actions challenging the validity of a trust, including tort claims that have the practical effect of challenging a trust amendment, are subject to this 120-day period. And then Imiri versus Shamtubi, 81 Cal App 5th, 606, the court held that filing a trust contest after the 120-day period has elapsed without probable cause can trigger enforcement of the no contest rule. So be certain to calendar this deadline very carefully. And finally, the trustee notification duties under 16061.7. So 16061.7 does require trustees to serve written notification on all beneficiaries and heirs of the settler when a revocable trust becomes irrevocable, typically upon the settler's death, right? And when there's a change of trustee of an irrevocable trust, or when the power of appointment lapses upon the settler's death. So these notifications must include specific statutory language advising the recipient of that 120-day contest period, and failure to serve those notifications on the beneficiaries exposes the trust to liability for all resulting damages, including attorney's fees and costs. Again, very, very serious. To comply with the 120-day notice provision and make sure that it's taken care of, or you're setting the trust up for some serious liability. Moving on to the next slide, please. Elder financial abuse and trust amendments. All right, we see this all the time in probate court, and I'm sure many of you have seen it as well. There is a recurring theme in recent California probate litigation, and it's kind of the intersection of elder financial abuse as well as trust modification. And as a judge, I was frequently called upon to make a decision about whether a trust amendment was procured through undue influence or fraud. We've got various beneficiaries and other people who are not beneficiaries but want to become beneficiaries, trying to get a larger portion of the pie. It's pretty sad, and it's pretty difficult to deal with from the point of view of the court. So basically, we've got undue influence as a ground to avoid a trust instrument. There was a case, Lintz versus Lintz, which is 222 Cal App 4th, 1346. And that's from 2014, where the Court of Appeal applied the contractual standard rather than the testamentary capacity standard to trust instruments, and held that in property-related transactions between spouses where one spouse is advantaged by a change to a trust, the presumption of undue influence arises under the family code. Interesting. And that's family code section is 721B. Recent cases have enforced this framework. So White versus Weir, which is from 2022, it's 76 Cal App 5th, also 5th 24, also held similarly. And it upheld an elder abuse restraining order, restraining an alleged influencer from facilitating any change to a settler's estate plan. Honestly, can't tell you how many of these cases we see. It's a lot. All right, then the elder abuse restraining orders in the context of a trust contest, right? So we've got elder abuse independent Adult Civil Protection Act, which is in Welfare and Institutions Code Section 15600, etc. And that provides a powerful tool in trust litigation. The case is White versus Davis. It's 87 Cal Act 5th, 270, and it's from 2023, where the court held that applications for elder abuse restraining orders based on alleged efforts to cause a settler under a conservatorship to change his or her estate plan did not arise from constitutionally protected activity and were not subject to anti-SLAPP dismissal. Good to know. In Newman versus Casey, which is from 2024, 99 Cal App 5th, 359, the court applied the four-factor undue influence test under Welfare and Institutions Code Section 15610.7, which deals with vulnerability of the victim, the apparent authority of the influencer's tactics, and the equity of the result, and in evaluating whether a deed transfer constituted financial elder abuse. So there's an intersection between conservatorships and trust amendments, obviously. And we go back to White versus Weir, 76 Cal Up 5th 24, again from 2022. And this illustrates a critical practice point for everyone. And that is when a settler is under conservatorship, any trust amendment executed without notice to and approval from the conservator and the probate court is highly suspect and may constitute financial elder abuse. Get it approved. Easy enough to do. File the motion, get it approved, notice everybody, and then you don't have to worry about a later, hopefully have to worry about a later motion for undue influence or fraud. It's just a nightmare. So petitioners advising trustees or beneficiaries must be alert to this issue. Next slide, please. All right, we've got issues with regard to no contest clauses. And, that used to be such an easy thing to draft, right? If anybody contests this will, they get nothing, basically. I'm paraphrasing, of course, but that's what we did a bazillion years ago. Well, there's recent developments in no contest clauses that really impact your drafting of the no contest clauses. So the statutory framework is within California Probate Code sections 21.310 to 21.315. And in 21.310B, a no contest a direct contest, is defined as a contest alleging invalidity, based on specific grounds, which can include forgery, lack of due execution, lack of capacity, menace, duress, fraud, undue influence, and it can be revocation pursuant to applicable statutes or instrument procedures and disqualification of a beneficiary. So we've got Key versus Tyler in 2024. That's 102 Cal App 5th, 365, where the Court of Appeal held that the scope of forfeiture under a no contest clause is not limited by law, and the courts must give effect to the trustor's intent as expressed in the clause, different than what we're used to. So this case arose from a beneficiary's judicial defense of a trust amendment that had been procured through undue influence, in which the court held that it was a direct contest of the original trust. And then the court further held that the probate statutes designate categories of contests that can support application of a no contest clause, but do not address the permissible scope of forfeiture once a qualifying contest has occurred. So what does this mean? What kind of a drafting implication is this for us as practitioners? We've got Avalos versus Swearingen, 16 Cal App 5th, 485 from 2017, that basically establishes that what we used to do, those of us who are older, a long time ago, those generic no contest clauses, they're obsolete. Can't use them anymore. Practitioners must draft each clause with particularity, specifying and identifying which instruments are governed by the clause, whether subsequent amendments are governed by the no contest clause. Important to put all this in there. And Probate Code Section 21305A3 requires that a no contest clause expressly identify amendments to the trust for the clause to apply to challenges to those amendments. And people are amending their trust, frankly, pretty frequently as things change in their lives, right? So a no contest clause in the original trust does not automatically extend anymore to later amendments unless it so expressly provides. Next slide, please. Practical implications for drafting and client counseling. Okay, we're going to talk here about synthesizing all of the foregoing developments that we've talked about and what you need to do as a practitioner, what things you need to implement. First of all, you need to anticipate and prevent a will contest. We've just talked about that to some degree about what the no contest clause has to look like, but also make sure you follow Haggerty versus Thornton. Make sure that you have explicit exclusivity language if that's what your client wants with regard to trust modification. And what you might want to do, and I would strongly suggest is a good thing if you have time, is to go through your notes of past clients and their trusts and determine, wow, when I interviewed this client, did they tell me I want this to be the exclusive and only manner in which the trust can be modified and exclude the manners provided in the probate code? Because if so, your language that you drafted in that trust may not be explicit enough to allow for your client's wishes, right? It may be vague enough, or it may not say that this is the explicitly exclusive manner in which to modify a trust. And you'll want to notify them, definitely give them notice and suggest they come in to make that modification so that they are in compliance with Haggerty versus Thornton. You want to make sure that you draft for all flexibility and contingencies, again, complying with Haggerty versus Thornton. And you should have in there information that states exactly what it is that the settler wants to be flexible on. And again, with regard to no contest clauses, think about the contingency or the possible future issue of amendments to the trust. You want to conduct comprehensive asset identification. Always a good idea. I can't tell you how many cases come before the court and we have to do Hagstead petitions because the assets weren't transferred into the trust. Almost always it's a piece of real property. And you want to go through and comprehensively identify the assets and make sure that they get transferred into a trust. When I was a practitioner, I actually did all that for my clients. I charge them, of course, and there's a recording fee and all the additional fees that go along with it. But it makes so much sense to do that. When it really comes up is when they take the house or the piece of real property out of the trust to do a refi and they forget to put it back in. And that's when you're doing the Hagstead petition to have that piece of property not probated, but just poured back over into the trust. Also, be really careful to select the right fiduciaries. You want to make sure that that's done correctly. These days, there are so many trust contests when you pick people that are fiduciaries that may not be welcomed by all beneficiaries and may fight. And it's probably, if you have a decent sized estate, pretty smart to pick a bank as a fiduciary. Next slide, please. All right, so be aware of these additional changes. Oh my gosh, there are so many. All right, the small estate limits have increased, which is great. So it allows a petition to determine succession to real property when the primary residence is valued at $750,000. Fabulous. That's going to potentially save years in court for those. I mean, in California, those are probably pretty smaller homes, or they're not necessarily in San Francisco or LA. but they're still going to be, it's still going to be helpful. Also, heirs can also claim up to 184,500 in personal property via affidavit. And this amount is going to get adjusted every 3 years. So the total threshold is at this point $934,500, which may now qualify for a streamlined process if the home is under the $750,000 cap. It's progress, I will say that. All right, so the transfer on death deeds, which is a pretty cool instrument in and of itself, because that wasn't always around, but the transfer on death deed has updated. And now the time frame for any conflicting documents like a new trust to override the transfer on death deed was reduced from 120 days to 60 days, which will hopefully reduce any long-term disputes about that. Transfer on death deeds is something I can't remember now exactly what year it came into effect, but it was long after I stopped practicing as an attorney. And it was always very frustrating to me when I had clients who really just wanted to leave their one piece of real estate and didn't want to do anything else, had no other property, and just wanted to be able to do that by deed. And there was no vehicle to do that. All right, I think, is there another slide? Yeah, there's not, but I have so much more. So I forgot the slides on the tax issues, but I really want to get into those to some degree because I think they're very, very important and we have time to get into them, and then we'll have time for some questions. All right, so the Tax Cut and Jobs Act of 2017 enacted some very sweeping changes to the taxation of vacation property, short-term rentals, that kind of a thing. And we know what those are. It made key changes, including reducing a cap on deductible mortgages, dealing with the state and local tax deductions. All of that has been to some degree codified or at least given additional time frame with the One Big Beautiful Bill Act that was signed into law last year. And makes most of those Tax Cut and Job Acts provisions permanent. So this $750,000 cap on deductible mortgage acquisition debt for qualifying residents stays in effect. The $10,000 annual cap on state and local tax deductions actually was raised to $40,000 through 2029. But remember that in California, there is no cap. This is the federal issue, but be aware that there are a lot of provisions that were in 2017 that were supposed to sunset in 2025 that now have not because of One Big Beautiful Bill Act. I love that name. It doesn't come off the top. So something to always make sure you think about. Something that came up well for me previously in court was the 1031 exchange law. So the 1031 exchange law allows you to exchange like-kind property, one rental for another, one commercial property for another, for example, and avoid paying taxes to some degree because of that. And so the 1031 exchange law permitted tax-deferred exchanges of both real and personal property for productive use in a trade or business or for investment. That has been modified. And now you have to actually have an exchange of actual real property to real property. So that's something to be aware of. And oh yes, this is another one that recently came up for me as well. And that is that if you are the beneficiary, or if you have a client that is the beneficiary of an inherited IRA, that must be distributed within 10 years of the original account holder's death, known as the 10-year rule. All right, so that's important to know because very few people nobody has really their IRAs in a trust. and the IRAs name beneficiaries. And then when the person who's a holder of the IRA dies and the person inherits it, they have to distribute it fully within 10 years of the owner's death. Another thing I wanted to touch on with regard to vacation homes. So Internal Revenue Code Section 280A governs the deductibility of expenses for dwelling units used both personally and as rentals. So this gets really complicated. So if a taxpayer uses that dwelling, which is a vacation rental, as a residence, and the personal use exceeds greater than 14 days or 10% of the number of days it is rented, then it deals with whether the residence test is met, and what's going to be tax deductible and what's not, and what you can write off and what you can't. So just be really careful to look into Internal Revenue Code 280A if your clients have a vacation home. And I think I had one big beautiful bill act that I wanted to touch on. We talked about most of the issues. Yeah, I think we actually got the ones that I wanted to discuss. And let me see if I had anything else. I don't. So I know I have things in question and answer. Let me see. All right, so the question is, under 15,800, is a court order required to deem it irrevocable? I don't think that that's true. I don't think that the court order is required. I think that if there's a contest, then definitely you're going to have to do that. But I don't think 15,800 requires the court to make an order to say that it's irrevocable at that point. Thank you for the question. Any other questions? Because I am rushing through and kind of rushed through and got through it pretty quickly. The declaration of incompetency, well, is sufficient then? Yes, absolutely. Again, unless and until somebody brings it to court, but you want a declaration of incompetency. And then if it's brought to court, you of course need to have the doctors, and usually it's two that will support that. You guys must have questions. I went through a whole lot really super quickly. I want to also reiterate that if I went too quickly on citing any of the cases or the statutes, to please make sure that you either text me, call me, email me. You have all my contact information. All right, so I've got one here. Since Haggerty, what is the most common drafting mistake you still see attorneys making with revocable trust amendment provisions? I didn't see a lot, to be honest with you, on that, but generally what they didn't do was they didn't state how the trust was to be amended in any specific manner. And so when there was a trust amendment, there were so frequently contests by beneficiaries and among trustees. So I, again, just reiterate that when you do draft, make sure that you specify exactly how the trust it can be revoked, and whether or not it can be modified, and if so, how it's going to be modified. Of course, it can be revoked, but how and when the revocation can occur, and how and when the modification can occur. All right, so Angela asks, under conservatorship, is a petition for substituted judgment the best method of satisfying the intersection? Yes, I really liked the petitions for substituted judgment. I think that those do well. Again, you've got to show, of course, the person's under conservatorship. You've got to show that the person who is requesting to be the person to, substitute judgment is the person that should be that person. I'm not saying that well, but you know what I mean. Yes, I love the petitions for substituted judgment. We saw quite a number of those. Joyce says the table of authorities is not in the materials she got. Okay, I sent those. I can send them again. Several people are saying that. Okay, on the other side, do you anticipate additional appellate litigation over what constitutes sufficient compliance with a trust's specified amendment procedure? Probably not a lot. I think Haggerty lays down the law quite clearly. I think it was very funny in the one case where they said, well, how about this written instrument that's unsigned? I think people are going to comply now with the Haggerty law. All right, I think I have a lot more questions. Small state affidavit, didn't catch the figure. All right, it's $750,000 for the piece of real property and 180. I have it written down. 182.5, I think, for a personal property, if I recall. But yeah, $750,000 is the amount for real property and 184.5 for personal property for a total of 934,500. If the court grants conservatorship over a settler and the names and names the conservator as trustee. Now income beneficiaries on the trust can ask the conservator trustee to make distributions. Depends on the terms of the trust. So that is a very good question. I can't answer that without looking at the trust to know for sure. Can a conservatee bring an order for a substituted judgment? It's usually the conservator, but the conservatee usually acts through the conservator. So I don't know how that would happen. I've never seen that. Something to look into, however. Need a clarification as to how accounting duties shift to beneficiaries when the settler becomes incompetent. Right. So that was in, let me go back to that, 15,800, I recall. I might have to find that and email that to you. Because that was back a little ways. And my notes are like really crazy. Let me see if there's something else I can answer. Do I recommend leasing a property under a special needs trust for conservatorship? I can't say I recommend that. You've got to be really careful about the special needs trust, about any income, and then dealing with the tax issues for your special needs trust. So I think that's something that needs to be answered by a special needs trust attorney, and they're very specialized, and I honestly cannot answer that one. I'm sorry. Have I started seeing petitions for reformation based on Packard, which are really contest petitions? I have not, but I just know that it's out there, and I think that that is a possibility that you need to know. In San Mateo County, where I practiced and where I was on the bench, I didn't see a whole lot of those, but it is available, and so I think it's good to know. As a former supervising probate judge, what filing, argument, or presentation issue consistently frustrated the court but could have easily been avoided? Well, we did a lot of interesting things in San Mateo County to avoid things. We did Hegstad petitions ex parte, which is not what the code suggests, but we did it in order to keep our calendars moving quickly. I think a lot of the issues that were frustrating that could have been easily avoided were discovery issues. And that's true and just not in probate, but also in civil and family law. Discovery is difficult. It's the bane of everybody's existence. And if people could just have a nice conversation, it would be so helpful. What I did, and I would strongly suggest that if your judge will do that on your case, to do it, and if not, try to do it on your own. I did a number of informal discovery conferences, and that is almost always, without fail, resolved all of the issues in a matter of a half hour, if not less. So that would answer that question. I really think that that issue is something that can be resolved if you just put a little bit of effort into it and you work well with the other side. Have I encountered AI-generated briefs or declarations that raised concerns, or what best practices would you recommend for attorneys using AI while maintaining their ethical duties? Okay, that's like a question that's near and dear to my heart. I actually formed and then chaired the AI committee for the court for 3 years until I retired. I'm big into AI. I love AI. I think that it is fine to use, and we actually put together a policy that it's a fine thing for attorneys to use AI in their briefs. They just have to comply with their ethics and duties as an attorney to not cite things that are hallucinations or incorrect citations to the court. So for me, AI doesn't raise any concerns. I know that I have colleagues on the bench who have had briefs filed that have had hallucinations within them, and they have handled that in their own way. We, of course, have heard about the cases in New York and other jurisdictions where attorneys have been sanctioned. I will say that do not use open chat GPT or items like that for your AI research. You will get things that are wrong. You will get hallucinations. And also, if you put any information into that, it will be available to everybody under the sun. So you can't ever use your clients' names or numbers or any personal identifying information or health information. But if you use a closed arena such as Westlaw or LexisNexis and you use their AI, which I do frequently, you can rely on what they have to say. It all comes within their arena of case law and statutes, and it's usually spot on, and if not, it leads you to where you need to go. So that is something that I am very supportive of. I think I got all of those. Warren raised his hand. Warren Worth. I don't think we can actually hear people, so I think that you need to put your question in the chat or in the Q&A. God, there's 21 now. There's probably a lot more. Majority of clients want the trust to remain revocable till the surviving spouse passes. Correct. Are there any restrictions on that under the probate code? Not that I know of. Absolutely not. Almost every trust for two spouses says exactly that. Initially, the settlers are the two spouses. When one spouse dies, then the other spouse is still the settler. Both of them were initially the trustees. When one spouse dies, the remaining spouse is the trustee, and not until the second spouse passes away is there actually a distribution generally, and that's done by whoever is named the next trustee. Under the big, beautiful bill, is there a rule that inherited IRAs be fully distributed, liquidated, or rolled over within 10 years? Okay, so what happened, I mean, I did this personally with my mom's inherited IRA, is that the inherited IRA has to be distributed. It got distributed to me with the distribution of all of the items in the estate. And then I, as the designated beneficiary, had an inherited IRA under my name, inherited from my mother. It had to be liquidated. You can't just roll it. Well, I wonder if you can roll it over into your own IRA. Thinking that probably is not valid. I liquidated it. I liquidated it within the 10 years as was required and paid the taxes. And I think that's generally what they're looking for on that. AI is great, but only if you create your own GPT, which can be exhaustive to build. Absolutely true. Yeah, good luck with that. I wouldn't even attempt that. Is a consent to a notice of proposed action satisfactory to satisfy changes as to specificity under Haggerty? I would say generally yes. If you get a notice of consent as to proposed action from all people who are interested parties, so contingent beneficiaries, and the um, and the trustees, then I think you're good. I don't think that any judge would say that flies in the face of Haggerty, but that's a really good question. That'd be something to see. Somebody's suggesting that the smallest state threshold is 208,850. Thank you, because I know it was increasing. So I've had a couple people say that. I appreciate that. Thank you so much. Things change. Yeah. Petition to determine succession to primary residence. How does the court determine whether a property was decedent's primary residence? Well, there's always evidence that's presented on that. Generally, there are people who will sign a declaration to that effect. If there are utility bills in that person's name from that location, that's usually helpful into making that determination. I haven't seen too many people actually contest that. People love to have those small estates just handled very quickly. So I don't think that would be a problem, but there certainly are ways to prove that if it would ever come up. Can real estate be invested in a real estate investment trust? Interesting. In 1031 exchange under the new rules. That is a really good question, Martina. I do not know. It's supposed to be, I feel like it's not, because now the rule is it's got to be like property to like property. So I feel like it has to be real property to real property, and a real estate investment trust, I'm not sure qualifies under the Internal Revenue Code as real property, as it's a group of real properties that are held in an investment trust. Interesting. I don't know. That's something to definitely check into. Do I have any recommendations for attorneys related to Packard? It's seemingly very chilling as it relates to 16061.7. Yeah, I don't, after the 128-day period has told. Yeah, that's a good question, Joseph, and I don't have any recommendations for that. And I did send the sites, Angela, and you should hopefully. Is the new law for a petition to determine succession retroactive prior to the law change? I do not believe so. I believe it is just from the law change forward. And the only thing that's going to change is the amounts for the real property. And Kevin says no. So thank you for answering that with me, Kevin. Okay, well, if there's no other questions, I'll hold out for just another couple minutes, but it was a pleasure. Nice to present to you all this afternoon. You're welcome. You're welcome. And you got the table of authorities? Yep, received. Excellent. Thank you, somebody, for telling me that. I'm glad it was informative. It was a lot to do in an hour. So I hope, it just gives you an idea of what you need to look forward to, what you should consider very carefully, and good luck with everything. Probate's the best. Love it.
Perfect.
Okay, Angela doesn't have the table of authority. She said help. I can see it, Angela. It's in the chat. It's the very last thing in the chat. You're welcome, everybody. Angela, did you get it?
If people are having issues, we can send them after the program as well.
That's true. She says she's still looking.
Still looking?
Angela, there's a thing at the very bottom of your screen where it says chat. And if you just click on that and scroll all the way to the bottom, it's the last thing in the chat.
She might be on mobile.
Yeah, that's true. Okay. Well, received. Yep. Excellent. Thank you, Marvin.
Perfect.
Okay, Angela got it. I feel better
Perfect.
now. Thank you, everyone.
Thank you,
Jose.
guys. You
Take
guys have
care,
a good
everyone.
one.
Yeah.
Bye-bye.
Bye.